Da 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 dum. Ay, 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 da da dum. All right, welcome, folks. Rambam. We are learning the laws of oaths. Let's get right into it. Chapter 7. So, when a person issues a financial claim against a colleague, which will require the latter to pay, were he to admit liability, right? And the colleague denies his obligation. He denies. And he takes an oath, or the plaintiff administers an oath to him, and he denies any obligation. If he is lying, the defendant is liable for an oath concerning a shvus apikadeh. So he's issuing a claim, and now the defendant has to take an oath. It's called shvus apikadeh. Pikadeh means of a claim of something, right? Of an object, an entrusted object. Yeah, that's what literally means. The halakha context, one takes such an oath falsely, you're liable to pay an additional fifth. Yeah, we learned that in the first chapter. And also to bring a guilt offering, right? The above applies even if the defendant does not respond. Ame. Uh, right. In other um, and other oaths, like for example, let's say a person says, I take an oath that I'm going to give such and such to charity, right? And the other person says, Ami to it, right? That means he's taking it upon himself. That similar oath, it applies, right? He has to say Ami in order for it to apply to him, right? Or he'll say, so be it, or whatever it is. But in this instance, it doesn't. Right? He doesn't have to respond Ame. Why? Because, well, he'll explain. But with regard to Shvus Apikal, then one is liable whether he took an oath on his own initiative or another person administered the oath to him. And he denied any obligation, even though he did not respond Ame. Why? For denying a claim against the plaintiff administered the oath is equivalent to responding Ame. Because here's a plaintiff who's making a claim against you. So that's like an equivalent to the Ame, right? I don't understand why he puts it in those terms exactly. In others, if he remains silent in response to the oath administered to the plaintiff, he is not liable even if he had denied the claim beforehand. Hmm. Okay. Number two, this does not apply when the plaintiff lodges a claim, which, if acknowledged by the defendant, meaning if he would admit that it is true, would not require him to make payment. Example, he lodged a claim concerning a kanas. A kanas is a penalty, right? For a person is not required to pay a kanas, a penalty based on his own admission, right? Only when you don't admit, then you have to pay the penalty. If you do admit for the wrongdoing, then you don't pay the penalty. That's the law. In such an instance, a person denied an obligation, he's exempt from the shvus apikodim, but liable for shvus bitui. So in this instance, he's denying, right? A penalty is shvus apikodim means there's an entrusted object. There's some object that is the plaintiff is claiming against the defendant, right? But in this instance, when it's be a penalty, it would not be of such it would not like I don't know. Second, let's see.
We have that in law.
Yeah.
Yeah, it's called an offer of judgment. So you make an offer of judgment. You have a car accident. You think your claim is worth more maybe than the policy of 100,000. And uh, if the verdict is, I think, a certain percentage above that, they have to pay legal fees and all the expert fees and everything on top of the verdict.
Mm-hmm.
So that's kind of the penalty I think they're looking at, because otherwise they could accept the offer of judgment and save that.
Right.
So
Okay.
that's kind of what this is.
Right. Got it. So in this instance, because it's not based on an object of something, so therefore you'd be liable for Shvuas means an oath of expression, a false oath regarding a past activity. Okay. I'm thinking, hmm. Okay, maybe let's see. Okay, similarly, if the plaintiff lodged a claim concerning landed property, a servant or promissory note, the defendant denied the claim and took an oath. He's exempt of Shvuas Bikodim, but liable for Shvuas Biti, for he took a false oath. Because landed property, a servant which is considered like landed property, and a promissory note that has no inherent value to it, right? It's just saying that so and so owes so much money, right? But it has no value, the note itself, right? No inherent value. So those three things are not considered to be part of an oath for a pikadon because it's not an object. I guess because it's landed property or it does have no value in and of itself in the promissory note. Right. So it's not when you have a plaintiff making a claim against the defendant of something, and something has to be something that could be okay, he's going to explain over here. Let's go. Why is one who took an oath concerning such claims exempt from the obligation of a false shvus of pikadon? Because were he to have acknowledged his obligation, he would have been held liable and required to pay what he denied. Because it states concerning an entrusted object, a financial deposit, a robbery, he oppressed his colleague, or discovered a lost object, all those things, right, are there would be a shvus of pikadon. All of this concerns movable property, which is if you admit his liability, he would have to make financial restitution from his own domain. This excludes landed property, for it is not movable property. For landed property is always revealed before its owner, and is always in their possession. Similarly, it excludes servants, for as an equation is established between servants and landed property, it's also considered like landed property. And it excludes promissory note for their actual substance is of no financial value, right? The paper has no financial value. So the law of a pikadon is a law of something that is hidden and you don't know. And therefore the plaintiff is saying, you have this, I gave you to guard my phone while I was away. Or, you found my phone. I know you because I got, and because witnesses came in, witnesses are a good example because then, someone came and told me and now he's away, told me that you found my phone. I can't have him as a witness. Right. So in that, but land never loses where it is, right? It can never be hidden. It's always revealed. So it doesn't have the same law. The above laws apply whether one took an oath after the plaintiff lodged a claim against him, or whether he took the oath on his own initiative, even though the claim was not lodged against him, was implied. If he took the initiative and said, "Why are you following me? Do I have any money belonging to you? I'm taking an oath that I'm not in possession of any of your money." Since he denied an obligation and took an oath, he is liable, even though the plaintiff did not lodge a claim against him. What's he liable for? In this instance, he's liable for Shvus Apikodan, right? Which means, as we said, you have to pay back if you found falsely, pay a fifth more, and bring a sacrifice. One is liable. Okay. One is liable whether he took an oath to the person to whom he owes the money, or to his agent who he is given power of attorney. For a person's agent is equivalent to his own self. Right. Same idea. Agent is the same idea. One is not liable for Shvus because unless he requires him to take an oath in a language that he understands. But the oath has to be taken in any language. Can be taken. It derives from. Okay. When a person consciously takes a Shvus Apikodan, he's taking an oath of Pikoda, right? Even though he takes a false oath and is warned by witnesses at the time that he takes an oath, he's not liable for lashes, but instead he must merely bring a guilt offering. For the Torah excluded him from those who are liable for lashes and obligated him to bring a guilt offering, whether he transgressed willfully or inadvertently, as we explained. Okay. All right, folks, we're going to stop here. All righty. Thank you very much. We'll see you later, Mitzvah Hashem. God bless you. Have a great day.